civil jurisdiction and occasionally sort of look at it in a regulatory framework. But I don't think we've actually matured our thinking about it, and that creates part of the problem we have in terms of the way lawyers respond to it. It's just, I guess, a comment more than anything else.
Does anyone on the panel like to respond to that comment?
I agree. That's very brief.
We've got actually someone from Victorian Legal Aid up the back to ask a question, which is, I think he might be able to confirm that there is some work done in Victoria.
No, I also actually just had a question of, is that working? Question for Carol or Helen, if Helen's still available to answer a question. It's just in relation to the new Victoria Act that's been mentioned. How, as an advocate, do you think we could use this Act, or what opportunities does it give us to use this Act for better outcomes in relation to systemic discrimination and even better outcomes for individual complaints, given some of the changes or simplifications of definitions?
Helen, do you mind responding? I can get the microphone.
No, not at all. Do I need to talk into the microphone? No?
Yes, I can't hear you.
Oh, can you?
Sorry.
Okay.
Can we get the other microphone now? Okay. We'll
I'm just worried I'm going to get kicked off here again before I finish. Just not really good. Well, I mean, I think that's a terrific question, and I guess the answer is there's a million ways. And one of the things that I think is really important with any new piece of legislation, notwithstanding all of the limitations that have been identified, is that we have to occupy the regulatory space as soon as possible to actually understand, to use the capacity of what the legislation is going to bring us. So, for example, we do have an investigation function, and Karen Toohey, our Chief Executive Officer, is sitting here. And one of the things that we've already started to talk about with other staff at the Commission is, you know, what are the early investigations that we can actually initiate that are going to, I guess, test the tool, but also achieve some systemic changes. I think where some of the provisions in our Act have been quite underutilised in the past, even in relation to individual dispute resolution. So, for example, the representative provisions, notwithstanding their shortcomings, are provisions that we should utilise and look at much more creatively in terms of how we can bring individual disputes. We will have, we've already implemented a significant change in our dispute resolution process to try to address some of those issues of time lag and you know, the need to kind of get to the resolution of matters as soon as possible when they occur, and to try to bring some balance in terms of how the parties come together on that. And I think that would, again, you know, be an area that we would really look at to try to get a better understanding on the part of advocates of how they can use our jurisdiction. We think historically we haven't done a bad job at using the incredibly light touch powers we have under the 1995 Act, just in terms of our research function, for example. And even there we would see that there are opportunities to kind of look more systemically at what can be done in those areas. And the last thing I would just remind you is that at least, I think, until next year, we still have a Human Rights Act that's in play, and we need to think about how, well, I don't mean that in a cynical way, but, you know, it is under review, and we need to think about the interplay with that as well. But, you know, we've had a number of, I guess, advocates who have come to us to talk about, you know, in their terms, what they would call class actions. I think, and I mean, I think Karen would agree that the provisions that exist under the new Act need to be utilised, tested, and we need to be creative about how we can actually get some outcomes that make a difference for people who are experiencing discrimination in a group sense or at an individual level. And we actually do genuinely believe the potential's there to do that.
Thanks, Helen. Thanks, Helen. Melanie?
Okay. I just wanted to confirm Anna's comments that Victoria Legal Aid does take on discrimination matters. I'm Melanie Schleiger. I'm a lawyer at Legal Aid working in the Civil Justice Program, and I specialise in discrimination law. I've been there 12 months, but we are building up our practice, and it's something that will take time. And because it is such a complex area of law, as has been and as has also been mentioned, they're often very resource-intensive matters that require interpreters and a lot of time to explain to clients the pitfalls of the law. I did have a question. It was encouraging to hear, Simon, you speak about the nature of the jurisdiction obliging tribunal members to extend more than formal equality to litigants. And I was thinking about how, as an advocate, you might convey that message to a tribunal member, and I wondered if you had any tips.
Well, I think if an advocate knew the Act and read the provisions and was prepared to draw a tribunal member's attention to the powers they had, they could ask the tribunal to exercise powers of inquiry, of calling witnesses, of not being bound by the rules of evidence. So as simple as responding to an objection you get by, when the objection is made to evidence and your response would be perhaps by reference to the tribunal's broader powers, where the rules of evidence don't strictly apply. So my first thought is use what's there, because I think most of the legislation around Australia does create a tribunal, not a court, and the practitioners tend to behave as if they're in a court, not a tribunal. Now that doesn't mean you get simply a response from the tribunal member, who themselves will be a lawyer, and it depends on their school of thought. But I'd push. I did once, as an advocate, appeal. I had a self-represented litigant who came to me with an adverse decision. I looked at the decision and I was appalled to see that the decision said that he had failed because he had failed to bring crucial evidence. And I thought, how could the tribunal sit there knowing that he hadn't brought the essential evidence and do nothing about it? On appeal, he lost the appeal on other grounds, and that ground wasn't necessary to be considered, so we never got anywhere. But I do think exploit the powers we have, and if you ask me, I'll extend as far as I can before the other side threatens me with crossing the bounds of procedural fairness, which is a legal advantage.
Any more questions?
I'd like to ask a provocative question. Is it time for us to have just one tier of anti-discrimination or equality protection should either the Commonwealth or the states walk away from this area? Is that one way of reducing, if not eliminating, the complexities that arise from the contradictions and differences between the various state and federal acts?
The only advantage I can see of a federation generally is that it does allow for some experimentation.
Yes.
And you do get little outliers like the ACT, who's bigger than its boots and thinks it can do something different, and you get innovation. And I'd be concerned that if, and I could pick on one or the other, or pick on the Commonwealth, if the Commonwealth had it exclusively, it wouldn't innovate, quite apart from constitutional considerations. So that would be a concern, I suppose. Changes of government bring changes of ideas, and things have moved forward for that reason. That's not a reason not to do it, but it's a consideration.
It would make it much easier.
Yeah.
For people using the system. There's no doubt it would be much simpler if there was a single system.
Yeah,
as long as it was a good system.
Yes. I agree with that, but I think the danger with all these things is whether you use the lowest common denominator to streamline everything, or whether you take it upwards. And my fear would just be that the easy thing sometimes is to use the lowest common denominator, so I'm a bit wary about that.
Which, of course, is the issue we're facing with the consolidation project. You might take that as a test of the lowest common denominator risk.
And I think most of you would be aware that there was originally some political will to try and harmonise state and territory and federal anti-discrimination laws and use the Standing Committee of Attorneys General as that forum. And that topic has, I guess, remained in that forum for some years without progress. So
No, they've got a website.
That's a development. But I think one of the reasons the federal government's moved on the consolidation project is because there just wasn't any progress through SCAG. Robin?
I guess it worries me when people talk about a single act. It often relies